And Cully, we've been so blessed to have you on our podcast as a guest several times now, and you've even gone out and spoken to a few schools for Constituting America. So we thank you for all you do to help us with our Constitution education programs. We're so excited to have you with us today.
Well, thanks, Kathy, and thanks to the team here. And Tova, congratulations on your matriculation at Harvard. And, I believe in the mission of this organization. I think you do the best job of any organization of its kind in the country. And so it's really my honor to be with you. And a quick update on my bio. I retired from the Navy after 30 years in February. So I'm just an old, washed up, retired Navy captain. So I'll have to update my bio. So would you like me to kick off the topic, or do you have a wind up for that?
Yeah, no, I think we'd love for you to just kick off the topic. And if you could give us a little, an entry level sort of introduction to the Fourth Amendment and all that it entails. And then we'll talk a little bit more about Fourth Amendment and new technology from there. And then we'll go to questions.
Great. Well, you guys have heard from some great scholars about the First, Second, no doubt Third, and then you jumped over to the Fifth Amendment last week. The Fourth Amendment plays out in our lives every day, whether you understand that or not. And I want to spend the first few minutes with you today sort of walking you through, because when you're talking about the Constitution or the Bill of Rights, you have to start with the actual text, and then what it actually means. And then give you some good news and bad news, and then walk you through some of the cases. And then, I know most of you folks are on the younger side, and so you're much more technologically savvy than people my age and older, and how the Fourth Amendment applies perhaps differently, if at all, to new technology and stuff that you're very familiar with. So I've asked Aubrey to throw up some slides here. The first slide is the actual text to the Fourth Amendment. If you could put that up there. And you see that there's essentially two clauses to the Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable, and we'll get back to that, searches and seizures. And then the second clause, the warrant clause, that no warrants shall issue, that means handed down by a judge, but upon probable cause supported by oath or affirmation. We'll get into that, in particular describing the place to be searched and the persons or things to be seized. So I want to cover a little bit of what it covers and how it's been interpreted. But let's jump right to the second clause and the term probable cause, because you may watch TV or Law and Order, or have taken some pre-law courses. But I think it's important that you understand the definition, and that will help you sort of move through the understanding of where we've gotten to in the Fourth Amendment. It's more than a bare suspicion, but less evidence that would justify a conviction. So remember, in a conviction in a criminal case, it's the highest form of proof known to the law. So the government has to prove beyond a reasonable doubt that somebody is guilty to each and every element of every crime charged. Others view probable cause as, quote, reasonable amount of suspicion supported by circumstances sufficiently strong to justify a prudent and cautious person's belief that certain facts are probably true. All right, so to even start the analysis of whether there's a Fourth Amendment violation, you have to get these terms down. Let's go to the last slide. Don't worry, I won't beat you over the head with any more slides besides this third one. And that's reasonable suspicion. Now, this is a standard defined in a case called Terry against Ohio. You must have heard of Terry stops, where a police officer can briefly detain you to question you. And there, the court ruled the police officer should be allowed to stop and briefly detain a person if, based on the officer's training and experience, there's reason to believe that the individual is engaging in criminal activity. So, different than probable cause that uses the reasonable person standard, reasonable suspicion is based on the standard of a reasonable police officer. All right, so we can take the slides down. Let's go back, because you remember, I'm sure, in the other lectures you've had about the amendments, that these were obviously not included in the Constitution. They came about later, and they came about as a direct reaction to the offenses that the King George III, was inflicting upon the colonists. And like many of these bills of rights, the states had moved out prior to the ratification of the original Bill of Rights with variations of it. So, for example, in 1780, the Constitution of the state of Massachusetts announced that every individual, quote, has a right to be secure from all unreasonable searches and seizures of his person, his house, his papers, and all his possessions. So you can see that language closely tracks what now is contained in the Fourth Amendment. I won't bore you with the whole history of how we got to the Fourth Amendment. You can read about it in one of my papers that's online. And you can also, if you want, read the Heritage Guide to the Constitution, which you can get online, and go clause by clause through the Constitution if you want a deeper dive. But suffice to say that one of the things that the folks that signed on to the Fourth Amendment were trying to get away from was this process of general warrants that were used in England. And those were court orders authorizing government officials to search and seize evidence with hardly any limitations whatsoever, or who could search or what they could seize. And so we were moving away from the general warrant into these specific warrants that describe things with particularity. Now, the Fourth Amendment was dormant until the 20th century for three reasons. First, it only applied to the federal government. Secondly, the concept of modern police officers hired by the government to investigate crimes did not emerge until the middle of the 19th century. And third, the remedies for violations of the Fourth Amendment remain uncertain until the introduction of the exclusionary rule, which I'll talk about in a sec, in a case called Weeks against the United States. That was in 1914. Today, in criminal cases, the Fourth Amendment and Fifth Amendment issues, as you heard about last week, are ubiquitous. You hear these things all the time. They're litigated prior to trial, and the Fourth Amendment and the exclusionary rule applies to the states and local police officers and the incorporation doctrine of the 14th Amendment, as you know, because you've heard about how the Fifth Amendment applies. So what does it cover? So I got some good news and bad news for you. The bad news is your parents, your grandparents, your brothers, your sisters, your annoying cousin can violate your Fourth Amendment rights. Sorry, Jewel and Jorn, you can violate each other's rights. There's nothing you can do about it. Your parents can search your room, your backpack, your purse, your car. Your siblings can do the same. Your grandparents can do the same. You can get mad at them, but there's really no legal remedy. They're not government actors. You might be able to sue them for money damages, but good luck with that. That's probably not going to result in anything. But what it does cover is government action. All right. And that's at the local, state, or federal level. So when there's government action and you want to ask whether there's a Fourth Amendment violation, you have to ask two questions. It's a two-step process. One, whether a government search or seizure occurred. And two, even if it did, was it reasonable? And that's where we're moving through this definitional jungle together. So what's a seizure? A person's property is seized when the government meaningfully interferes with a person's possessory interest in that property. So if they take your property away, or they force you to move out of a home, or they take a package or letter during the course of delivery, that's seized. A person is seized under the Fourth Amendment when the government terminates or restrains her freedom of movement, like when a government official places a suspect under arrest or temporarily detains a person where a reasonable person would not feel she's free to leave. What's a search? This is the one where I think there's the most interest and it gets a lot of attention. And there's two tests for a search. First, the government conduct is a search if it is a trespass onto a person, a house, a paper, or an effect with the intent to obtain the information. And that was reaffirmed in Jones against the United States, the 2012 case from the Supreme Court, which we'll talk about. And second, the government conduct is a search if it, one, violates a subjective expectation of privacy and society is prepared to recognize that expectation as objectively reasonable. All right. So I know this sounds like a bunch of lawyer mumbo jumbo. So let's get into some hypotheticals here, because I think that's more interesting. And I can apply these things for you. So let's say, Jordan, you're driving your car, all right, and you get pulled over for speeding. And the officer sees an open beer can in your cup holder, all right, and he suspects you've been drinking and driving, not that you would ever do that. He performs field sobriety tests and arrests you for drunk driving. Can he pat you down and search your person as incident to the arrest? And can they conduct an inventory search of your car? What do you think? I'm not going to ask your brother because I know what he's going to say. Heck yeah. What do you think?
I would say, yes, they can pat me down. Well, yeah, I would say yes to both because they found illegal substance in my car.
Right. And that's a reasonable search. And those searches have been upheld by the court. Let's move to a home. The rules for searching homes are somewhat more restrictive than cars. Why? Because a car is mobile, whereas a home is your castle and it stays put. And so in the case of a home, an entrance is constitutionally reasonable only pursuant to a valid warrant or an exception to the warrant requirement. That would include exigent circumstances, emergency circumstances. So let's say, Tova, you are a volunteer police officer for the Cambridge Police Department there in Harvard, since you don't have enough to do. All right. And you hear about a noise complaint from a neighbor. So you go out to the house and an adult female opens the door and you ask her, hey, can I come in? And she says, sure. And when you walk into her house, you see illegal drugs or weapons on the coffee table. It's in plain view. Can you seize that evidence as a government official, since you're a volunteer police officer under the Fourth Amendment? Or do you need a warrant? Do you need to leave and go back out and talk to a judge and convince the judge to sign the warrant?
I believe that because it's in plain view, that means that you would be able to seize it since you were invited in and it's in plain view.
Right. So there's a two-step part, and this is why you're at Harvard. One, you got permission, consent from the putative homeowner. And two, it was in plain view. All right. Let's change the hypo here. Let's say the house is on fire and you're still a volunteer police officer. So you get to wear a uniform, you have arrest capability as a part-time police officer. And the firefighter tells you, because they're trying to put the fire out, hey, you cannot go into that house because it's burning and the fire could, result in your death. So don't go in there. But you hear a little kid crying. So you're a good person, because we know you're a good person. So you sprint into the house anyway, take your life in your own hands. And while you're picking up the little boy, you see 5 illegal machine guns and a kilo of cocaine in the house. And you take the kid, you save the day. Can the evidence that you saw that didn't get destroyed in the fire get admitted into trial against the homeowner, the defendant?
That's
Or is that
very
a violation of the Fourth Amendment? You had no permission. You didn't ask anybody. In fact, the firefighter said, don't go in there.
I would say no. Cautiously, it would not be able to be used since you didn't get explicit permission. Even though it was in plain view, you weren't invited into the house, so you didn't have an ability.
And Jordan, what do you think?
I could see the emergency circumstances might make that different.
Okay. So do you think you can or can't admit it? No. Jordan, Jewel, what do you think?
I don't know. It is emergency circumstance. So just so that there's 2 different answers, I'll say yes.
You're correct. There was no homeowner there to ask. There was an exigent circumstance. It was in plain view. And there are cases that would allow that evidence to be admitted at trial. Cars, I have some good news and some bad news for you. And we're going to get to new technology, but we're getting there through cars now, and that's where we're going to get there. You keep your Fourth Amendment rights when you get into your car. But the bad news about cars, as I tipped my hand a little earlier, is that the rules for searching cars tend to give the government significantly broader powers. And so a police officer, for example, can order a driver to pull over when they light them up. And they can also ask and seize the car and its occupants if there are visible traffic violations that happened at the time. All right, so that's bad news. So good rule of thumb here is don't break the law when you're driving your car. The driver can arrest, the officer can arrest the driver based on only a minor violation, even if the crime does not, even if the crime of arrest does not provide for any jail time. That's a case called City of Lago Vista, the 2001 Supreme Court case. Before we get to the new tech, I want to ask you and explore a little bit with you about the remedy. If there's a violation of the Fourth Amendment, what happens? What is the remedy? Just in general, what does it prohibit? And what is the remedy? Do either three of you have any guesses? Tova, let me start with you since you're the lady. I'm the judge. Judge Stimson finds that Officer Gilbert over there violated the defendant's Fourth Amendment rights. This is the item that was seized in violation of the Fourth Amendment, this blue pen. What's the remedy?
I'm trying to remember back to my AP government first semester last year, but I believe that isn't there an exclusion rule where if evidence is seized through a violation of rights, you aren't able to use it as part of the trial against the person?
Yes, that's right. So the exclusionary rule essentially says that the government, in its case against that defendant over there, cannot move into evidence this pen during their case in chief. Remember, they have the burden of proof and they have the burden of persuasion. They go first in a criminal trial. So the government can't do that. All right, it's out. Right now, sometimes that means you can't even have a case to bring in the first place, because if the main piece of evidence doesn't come into evidence, then the government sometimes can't make their case. But let's say that's just one of many pieces of evidence in this robbery or something, then that piece of evidence comes out. What if, however, because there's always exceptions to the law, what if the defense attorney then says, now, Officer Jorn, didn't you find a blue pen in my client's house? And of course, that's a dumb question because he knows it and the evidence is already excluded. But sometimes the defense opens the door in the trial and the government can say, hey, he brought up the blue pen. I now get to put it in evidence in my rebuttal case. So sometimes when the piece of evidence is excluded under the Fourth Amendment by the exclusionary rule, it finds a way back into the trial later on if mistakes are made or certain evidence plays out. But for the most part, the remedy is excluding the evidence. So it's a big deal. So when I was a criminal defense attorney, I always wanted to try to knock out some government evidence. And that takes us to these tech cases, all right? Because I want to get to the tech cases because I know they're of interest to you. Every single one of you has one of these things, cell phone, right? And there's a lot of stuff on that cell phone. There's a lot of stuff on there that you don't want your friends, your parents, your boyfriend, your girlfriend, your teacher, anybody to see. And so, you know, from probably just your gut instinct that when you're a student in a high school, you have a diminished sense of privacy because schools can go into your locker and sometimes into your backpack under certain circumstances. But the phone is a different deal, all right? You also should know, just as a technological matter, that when you're using this phone, it sends out a signal to a cell site location tower. And when you move from Cambridge, Massachusetts, over to Medford, down to, Harvard, down to some other part in Boston, or you move around wherever you guys are in Maryland, as you move from place to place, the signal goes from a cell site location tower to another one, to another one, to another one, and hopefully you don't miss any signal. Well, those records are kept. but they're not kept by the government. Just like when you use a credit card, right? The Visa or MasterCard or American Express holds that. Just like when you go to your bank and you deposit some money. These are held, this information, which you think is yours, is actually held by a third party. And so the government oftentimes, when they're trying to build a criminal case, can go to these third parties and ask for information, evidence about you. And the Supreme Court, for the most part, has held that these under this doctrine called the third party doctrine, you don't have standing to object when the government asks for your bank records because they're not held by you, they're held by a third party. But that came to a head in a case called United States versus Jones, all right? And this is where technology comes into play. Jones was a drug dealer, all right? There's no one disputing that he was involved in the drug trade. But the police, you know what those little Apple tags are? You know what those things are? Those little round discs that you can...
Are they air tags?
Exactly. Well, the police also have a similar thing like that, and they put one of these tags up there under his car, and they had a permission to do it, a warrant to do it, but it was only for a certain number of days. But they kept it up under his car and tracked where he went for 29 days. And it showed that when you added it all up, where he was going and what he was up to, and it was introduced into trial at his case. And the Supreme Court in Jones said, whoa, 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 whoa. When you aggregate all of that information that's held by a third party, you're providing a very discriminating picture of what this person is doing, and you're violating his Fourth Amendment rights because you exceeded the scope of the warrant, which was to let it ride around for 10 days. And when you are doing that, even though it's held by a third party, this information is in the aggregate too discriminating, and it violates the Fourth Amendment. Similarly, and I'm going to stop at this one, in a 2014 case called Riley versus California, it held that the police, prior to that decision, if you got arrested and you had a phone on you, the police could ask you for permission to get into your phone, or they could get into your phone and find out what's on your phone because it's being held by Verizon or AT&T or whatever cell phone provider you're using. But the court held unanimously in 2014 that the police generally may not, without a warrant, search digital information on a cell phone seized from an individual who's been arrested. So why? As I mentioned in this paper, the Fourth Amendment paper on genetic information, which is, these papers are all on the Heritage website. You can download them for free. Chief Justice Roberts basically said that cell phones are essentially mini computers that have your whole life. Just think about what's on your cell phone, right? You have all your contacts, you have all these texts, you might have end-to-end encrypted messaging going on, you have all sorts of pictures, you have videos, stuff that, of course, when the founders and then the ratifiers of the original Bill of Rights were around, they couldn't even conceive of that, right? And so in the aggregate, and where the Fourth Amendment is moving, is trying to grapple with this aggregation of information. It's one thing to ask for a warrant to go search Tova's backpack at school, or any one of you guys' backpacks at school, right? It's another thing to try to get into her computer or your computer where you know all the stuff that's on your computer. You may have forgotten a lot of the stuff that's on your computer. Just imagine giving the government access to that treasure trove of information. And so in the Jones case, and let me just tell you about two doctrinal strands that are happening at the Supreme Court right now. And by the way, this does not break down conservative justices on the one hand and liberal justices on the other hand. This really blends with the various justices, because you had Scalia and one of the liberal justices joining in the Jones decision. And in fact, writing for the majority, Scalia wrote, quote, "The government physically occupied private property for the purpose of obtaining information." This is in the Jones case where they put the tag up under the car. Quote, "We have no doubt that such a physical intrusion would have been considered a search within the meaning of the Fourth Amendment when it was adopted," unquote. So he's going down the property rights. This is property, and therefore it is not appropriate. And one of the and some of the liberals joined him on that. And then you have others on the court who dissented, who said, no. This is held by a third party. And therefore, under the third party doctrine, this is not a violation of the person's Fourth Amendment. They voluntarily gave up that information when they agreed in the contract with AT&T or Verizon. Now, I challenge any of you to go to your local Verizon store and say, "Jordan, I want you to try this, okay? Try this weekend. Go into the mall and take your phone, all right, and say, 'Hey, buddy,' the guy working behind the counter, 'I want to continue to use your service, but you're not allowed to keep my cell site location information, okay?'" Now, this guy's going to look at you like you got 6 heads, because that's the way it works. That's the only way that your phone can actually work, as it crosses cell site location information. And plus, it's a business record for that business, and so they have to keep that information. But the question for us today, and I hope we discuss during the Q&A, which Aubrey's giving me the look, which means I better shut up, is what should the government have to do to get to that information? And is a search of that nature a government search? I think the answer is clearly yes. And is it reasonable or unreasonable, especially when the information is in the aggregate in the hands of a third party? And that's tough stuff. That's tough stuff. And the court is at really an inflection point since the Jones and Riley and Carpenter cases. So I'll stop there, and we can play Stump the Chump. And you can ask me any question. If I don't know the answer, I'll tell you I don't know the answer. If you need a case, I can point you to a case, but I'll stop there.
Well, thank you, Cully. That was such a thorough and really great explanation of the Fourth Amendment. I know I learned a lot just in that short amount of time. And Tova, I'm going to go right to you because I know you've got to get to class here in a few minutes. We don't want to make you late this far into the semester. So I'm going to turn it over to you for some questions.
Thank you, Kathy. And yeah, thank you so much for that great overview. Super thorough. And I just have a few specific questions. I think I was studying in the law school earlier today, so I think I'm in a lawyer mood.
Okay.
So, you were talking about how the circumstances are different if there's like imminent danger or emergency, but like who decides that? And who's to say that like a police officer couldn't like retroactively claim that it was an emergency if they illegally seized evidence or violated someone's rights? And how is that determined?
Well, that's a perfect question because it gets to, for example, the incident that happened 2 different times in the United States recently, one down in the Naval Air Station in Pensacola, Florida, when a disturbed individual from a foreign country who was in the flight school there shot up and massacred several U.S. naval pilots and other people at Naval Air Station Pensacola. And he actually shot a couple rounds, Tova, into his own phone, thinking that he would disable the phone so that the police or FBI or CIA couldn't get into his phone. And then they got the phone. They found that it was, they were able to get in, they potentially be able to still use the phone, but they needed his password to get into the phone. You saw another case from out in California where the FBI wanted the password to get into the phone. They claimed it was an exigent circumstance. They couldn't get consent. And so they asked Apple for that, an ability for a backdoor to get into the phone. And Apple said, we don't have the ability to go backdoor. We don't create these backdoors. So what happens in that situation, whether it's those two situations or a more garden variety case, Tova, is the government has the burden to show during the pretrial motions that the exigent circumstances or so-called exigent circumstances were indeed exigent circumstances. So what happens? They stick Officer Gilbert on the stand, and the government prosecutor asks him questions, and then you, the wily criminal defense attorney, or me, the wily criminal defense attorney, cross-examines him. And that's where the crucible of cross-examination, which has been a welcome change from the system they had in England, the inquisitorial system, has been the engine of truth seeking. And so the government may claim that it was an exigent circumstance, but it was fake, and it wasn't. And so that's where the judge ultimately, after direct and cross-examination and pretrial motions, will make a decision of whether, in fact, it's an exigent circumstance. A similar type situation, which you may have talked about last week, is in the Fifth Amendment. So if somebody says that they asked for a lawyer, and after they were Mirandized and the police ignore it, then the police officer is going to have to take the stand in that case, pre-trial, and the government prosecutor is going to have to ask the officer questions. And then the defense attorney will say, well, isn't that true that the first thing that came out of my client's mouth was, I want a lawyer, I'm not talking to you? And then the judge will make the decision of whether or not it was a free and voluntary statement by the accused, or whether it was taken in violation of his Fifth Amendment right to remain silent. And so it's always the government's burden to prove that. The only defense burden in any case is an alibi defense. Otherwise, the burden always falls on behalf of the government, which is the way it should be.
Thank you so much. And then could you talk about the process for getting a warrant if they wanted to, go into someone's house or property?
Sure. Well, first off, remember, it only applies to the government. So Jorn cannot go get a warrant to search Jules' stuff. He can just go rifle through it, just like you can rifle through Kathy's stuff. She won't like it. It would be bad manners, but you're not a government actor. So a police officer, a sheriff, a person of the law, a prosecutor can fill out an affidavit. An affidavit is a fancy word for a long document. Doesn't have to be long, but a document that lays out specifically, my name is Tova Love Kaplan. I'm a police officer with the Cambridge Police Department. I've served in that capacity for 15 years. I attended the following schools and I have the following qualifications. On such and such a day, I was assigned to the case of blah, 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 blah. In the course of that investigation, you lay out all the things that you believe rise to the level of reasonable suspicion and probable cause that a crime was committed by this person, and that you need a warrant from that judge or magistrate to search this place for these specific things. Remember back to the original definition, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. So if you say, I'm looking for a 38 caliber handgun, and it's at 123 Smith Street, Middletown, Virginia, and I have reason to believe that it was used in this homicide because a 38 caliber slug was found in the deceased's body, and all these other facts and circumstances that would lead you to believe that you have probable cause to believe that this person committed this crime and that gun is in that drawer or that bedroom or that house, then the judge, and I was a judge for 5 years, as you know, will take a look at that affidavit. And if reading the affidavit, the judge believes that it sufficiently complies with the warrant requirement, that there's probable cause supported by an oath or affirmation, because you would sign at the end saying, I swear or affirm under the penalty of perjury that the following facts are true. You sign it, you hand it to Judge Stimson. Judge Stimson in his chambers, or her chambers, if Judge Stimson's a female, and then I would read it. And then I will either sign it or not sign it. If I don't sign it, too bad. You got to go back to the drawing board. And sometimes judges don't sign it. If they sign it, then I hand it back to you. You take it, and then you execute the warrant, which means you take that paper, you go to that house. Now, if you think there's a reason that you could be in danger, you might take a few backup people with you. You knock on the door, and if you have to, you can break into the house because now you have a warrant. So if no one's there, you can break the door down and you can go execute that warrant, which means you can look for you can go to the place and search for the thing that you described in that warrant. So, question, Tova. You do just that. You're looking for that .38 caliber handgun that was used in the homicide of Susie Smith, the ex-wife of Bob Smith, who's the defendant, who you think is the guy who killed her. And you get into that house, you're rifling through his drawers, you find the .38 caliber handgun, and next to the .38 caliber handgun is 6 kilos of cocaine and $40,000 in tightly bundled money. What do you do with it? You got to go back to Judge Stimson and say, hey, Judge, hello, got some other stuff. Do you just take it? Do you call your boss? Do you phone a friend? What do you do? Where's the Fourth Amendment part come into this in your head?
I think you would likely have to get another warrant just because it was specifically mentioned that you were going in for a specific object. Whereas I think the situation would be different if you found the owner of the house and you asked him specifically, oh, can we look in your stuff? And he said, yes. I feel like that would be a broader permission to use anything in the drawer. Whereas if you got a warrant specifically looking for the gun, I would say you would likely have to get permission for the other things.
Jordan or Julie, you want to add anything to that comment?
I think that they would, if it was cocaine, let's say, I think the police would have to take it when they saw it, but then it may not be able to be used as evidence.
What do you think?
Yeah, I don't think it. But after that, I don't know.
Because they have to get a warrant, I
But
guess,
it
from what you
does make
said,
sense
but I don't know if they could just leave it there unless they were
to
going
have
to
to
try to
take it.
take the risk of, all right, let's run, get a warrant, and then get back and pick it up. I don't know.
Yeah, so all of your gut instincts are right. Of course, the one piece you're missing, and that's just because you haven't practiced in this area yet, if you choose to, is that they'll secure the scene, right? They'll secure the scene. They're not going to let whatever his name, whatever name I made up, Billy Bob, whatever name I gave him, back into his house. They're going to secure the scene. They're not going to let him get it back in there. So the coke and the money is not going to walk away. Tova, you're exactly right. I like your gut instincts. You have conservative legal instincts here. The conservative, smart way to do this is to go back to the court and say, hey, Judge, I found the gun in the place I asked to look under the warrant that I put in front of you that you signed. By the way, I also found this cocaine, and cocaine's not legal, so it's not like you get to leave it there. And the money may be his money from his beehive business or his, drone business or whatever. It might be legally gotten money, who knows? But I think, if, for example, in the murder, he got the money from the insurance policy and he was murdering her not only because he hated her, but also because he had a financial incentive, maybe that money matches the exact amount on the policy. So you may be able to figure out from other facts and circumstances how the cocaine and the money has some tie into the murder, or maybe it's just he does distribution of drugs on the side and he's also a killer. But either way, you're going to secure the house. You're going to go back and get a warrant. That's the smarter thing to do. Some cops would just grab it. I think a lot of cops would just grab it. I think the smarter thing to do is to go back and get a warrant, and then and the warrant, you'll describe in the new warrant how you came across it, and then let this guy, who's now charged with murder, move to suppress the drugs and the money. And good luck with that. I think that's coming in probably a separate trial, because that defense attorney will now try to carve a deal for this guy, because he's looking at two pretty serious sets of crimes in front of him. Does that make sense, Tova? I mean, your gut is right. I like the way you think.
No, it definitely makes sense. And then just my last question before I turn it over, because I'm just curious. What about like shared property? So let's say, this amendment applies to the government, you said, but let's say like the wife went into her husband's stuff and like took the evidence and then handed it, and then goes to a police station and says, hey, like I found this.
Now, you know the answer.
Done.
Is she in the government? Does she work for the government?
No, she's not, but is the government like
that's why you need to marry well, right?
Mhm.
That's why you need to marry well. But on a more serious note, let's ask a more typical situation. Okay, I'm just going to twist your hypo just ever so slightly. Let's say, do you have a roommate in college?
I have 5.
Yeah. Okay, perfect. And you're in a suite, right? And there's, you'll have your own beds, et cetera, and you have a sort of a common space. That's a typical situation. Or let's say it's a husband and wife, or a boyfriend, girlfriend, or a boyfriend and boyfriend. They live in an apartment or something. And the police knock on the door. And let's say they knock on let's say it's a boyfriend, girlfriend, and they're renting a place here in DC. And the police have reason to believe that he is a drug dealer. They're not sure she is, but she's up to something. So they knock on the door and say, hey, is he in? And she says, no, he's not here. He's been gone for a couple of days. I don't know where he is. And they say, well, do you live here? Oh yeah, I live here. Do you pay the rent here? Yeah, I pay half the rent. Do you pay utilities? Yeah, I pay half the utilities. That's my boyfriend. Do you mind if we search the place? Yeah, sure, go ahead. I have nothing to hide. And let's say she doesn't even know he's up to this stuff. And do you guys share the same bedroom? Yeah. Can we search a bedroom? Sure. Goes in there and finds all the drugs in their shared dresser drawers. Sorry, that was valid consent. And that's why you gotta, choose your roommates and spouses wisely. But in terms of valid consent, that is valid consent. And so if, for example, the person who opened the door is a guest and they were just got there, the defendant, who later is charged with the possession of drugs, would have a pretty good argument that they did not have the lawful authority to give valid consent for a search. But people who share an apartment, spouses, roommates, Tova, if your roommate says, sure, you can come on and look through Tova's stuff, you're going to have a tough time saying that she did not have the ability to give valid consent. And I know you got to run across campus to go to class, but great to see you. I hope you're thriving there.
Thank you so much. Have a great day.
You too.
Okay, Jewel and Jorn.
So we were talking about the technology, and then you had said about getting a warrant. So if the government, the government goes through the process of getting warrants for looking through cell phones, and then what is this? What is a subpoena?
That's a great question. So, yeah, I should have put up a slide, Aubrey. If you remember, remind me next time. I'll have a slide on subpoena. A subpoena is a document that's used in litigation, oftentimes just signed by a lawyer, sent to another party. In other words, a lawyer for an opposing party that says, produce this. It's essentially a very strong demand letter. Think of it that way, without getting into the technical or history of a subpoena. But a grand jury, which sits in secret, can issue subpoenas at the request of a prosecutor. That's what people typically think of as a subpoena. A government official will subpoena documents. Let's say I think Jorn is running numbers on the ponies down at Pimlico, and I think he's got all those receipts in his Nike backpack. So I go to the grand jury, I get an indictment against him for running numbers on horses, and the grand jury issues a subpoena. That happens, yes, and of course, Jordan, of course, is not doing that, but the more typical use of a subpoena is a lawyer just sending a document, which is sort of like a letter, let's just call it a letter, to another lawyer of the opposing party and just saying, you know, I'm subpoenaing all phone records or all employment records. Let's say it's an employment discrimination case, going back 10 years for all the employees that you hired who were female or minority or over the age of, or I want to subpoena, any persons you fired who were over the age of 60 because it's an age discrimination suit. It's a demand letter. That's all it is. So
And then
in other words, it does not have to be signed by a judge. A warrant does. That's the difference.
so if a subpoena is ignored, then basically it just makes you look guilty, or there's no recourse if the subpoena is just not given, if you don't give the information.
No, lawyers are all members of a bar, not where you have a sip, but a bar, a professional association of lawyers in that state. That's why you take the bar exam. And as upstanding and lawyers in good standing of a bar, they have certain duties, and they cannot issue a subpoena without good cause and without knowing that that party is likely in possession of that information. And so if you two are suing each other, let's say you're not brothers, and let's say your lawyer, Jewel, sends Jorn's lawyer a subpoena, and Jorn's lawyer blows it off or doesn't answer the questions in the subpoena, then your lawyer can can file a document with a court to say, hey, Judge Stimson, I issued this subpoena. They blew it off. They had X number of days to comply with the subpoena. They didn't do it within a timely fashion. I'd like you to enforce the subpoena. And by enforcing the subpoena, that means the judge gets involved, and then the judge goes to Jorn's lawyer and says, hey, McFly, you cannot be ignoring these subpoenas. You're a lawyer, and you have a duty as a member of the bar to comply with this subpoena. So it's more than a strong letter. It is a legal document that has legal significance with timelines attached to those subpoenas, depending on the state law involved. So if you ever get a subpoena, I'm not giving you legal advice, talk to your lawyer if you're having legal problems, but if you get a subpoena, do not blow it off. It is a legal document that has certain time frames attached to it, but it has nothing to do with the Fourth Amendment. It is not a warrant. It is not signed by a judge, but it is one of those other words that's out there, and I'm glad you asked about a subpoena.
Yeah, wow. So I was thinking about how in the world we could relate the technology situation and the Fourth Amendment to what in the founding fathers' time would be comparable. And it's almost like if you had a sack of letters that you wrote of all of your communication, and the founding fathers had just carried around all their letters, people in 1776. So how did the law apply to that? Or how does the law apply to that?
So I like the fact that you're being creative to try to find an analogy. I just don't think that there is one that fits neatly into your question. And the only reason is not because of the deficiency of your question, but because technology has enabled us to do things that were unthinkable and not doable back in 1770s, 1780s, 1790s. When you're talking about gigabytes and terabytes of information, look at I'm rereading a biography about Alexander Hamilton, and a lot of our founding fathers were really prolific letter writers and just writers in general. But when you I guarantee you that if you added up all the stuff that John Adams wrote, and all the stuff that Jefferson wrote, and all the stuff that Hamilton wrote, and all the stuff that Madison wrote, and you put it all together, it'd be a lot less than all the information on your cell phone right now.
Yeah, which is kind of crazy because it
Yeah,
really is.
and it's not because you're a prolific writer. I suspect you're a good writer, but it's because of all the gigabytes of information, of video,
Oh.
pictures, calls, texts, and all the rest of it. And so this is to me, as a Fourth Amendment geek, which I'm proudly a Fourth Amendment geek, this is the most interesting part about the Fourth Amendment. And it's only going to come more into play as you guys start losing your hair and getting gray hair, because technology is improving and increasing and allowing for things that were just unthinkable a while ago. And so that's where the court is really wrestling with not whether the Fourth Amendment applies to new technology. Of course it applies. It's how. And, you know, what is a reasonable search and what is a reasonable expectation of privacy? I mean, when Kathy and I were growing up, and I'm sure I'm older than Kathy, but when Kathy and I were growing up, our sense of a reasonable expectation of privacy is a heck of a lot different than yours. I mean, you guys take pictures of yourselves day in and day out, you know,
Not all of us. Some of
post it out there. And, you know, we just didn't even think that way. Number one, we didn't have the ability to do it. But secondly, we don't put ourselves out there like you guys. And so this expectation of privacy over the years has been changing. And so the court is grappling with, you know, is it government action? If not, it's outside the Fourth Amendment. If it's government action and triggers the Fourth Amendment, is it reasonable? Is it unreasonable or reasonable? If it's unreasonable, it's out. But the question is, you know, does this aggregation, does the fact that technology allows us to uber bundle information that's yours or partially yours, but held by a third party, does that provide such discriminating information about you such that the Fourth Amendment is triggered? And that's the $100,000 question. And the answer is, it depends on the facts of the case. So you got to look at the Kilo case, for example. Kilo was cops figured that Billy Bob over here was growing pot in his house. So they used a thermal imaging device. Why? Because pot growers use lots of electricity to get their green thumb pot growing, right? They used a thermal imaging device and realized that, yeah, they got all these lights growing in this house. They get a warrant based on the image from the thermal image to show there's lots of lights. They go in there and what do they find? Pot. Well, it was Scalia who objected and dissented. It said, no. This is an invasion of privacy, this thermal imaging device. It was not contemplated at the time of the ratification. So that's a violation of the Fourth Amendment. So it's all of these new technologies that are stress testing the Fourth Amendment. The Fourth Amendment is going to survive, don't worry. But it's how much information is the government able to get because of the aggregate amount of information that you and we and the rest of us are using and creating as a member of modern society.
I
Well,
wonder how much more.
Go ahead. Go ahead, Kathy.
well, and because we're right at time, and I want to get to at least one audience question if we can. Robert Spiegler asks, for the Jones case, could the data from the first 10 days be admissible in court?
So that case was remanded, in other words, sent back for further findings. But the answer, and that's an excellent question, there is language in that opinion that prosecutors and police are using to this day that suggests that they can be on safe grounds to get that information for about 7 days.
Okay.
And so many prosecutors are moving out on the 7-day sort of temporal limit of the Jones case, but much more than that, they're really putting themselves at risk for losing all of the information.
Well, thank you. Thank you, Jewel and Jordan, for your great questions. And Cully, thank you for your very thorough analysis. It's so engaging. And we want to also encourage all of our listeners to once again go on the Heritage Foundation website and look for the interactive Constitution. that you all have on there. It really is a great resource, and you can Google Cully Stimson and Fourth Amendment, and all of his wonderful articles come up. So we thank you for your time. We want to give a quick shout out to our students who are on with us here today. We know we've got Terry Zalesnak and Cami Winehouse have some homeschool students, and Tiffany Smith from Hamilton County Virtual School has a classroom full of students. And if you've got students watching, be sure and write it in the Q&A, and we will give you a shout out next time. So we want to thank you again and encourage everybody to come back and join us next week as we go through the Sixth Amendment. So I'll give you all a chance. Anybody have any parting words that they want to leave us with?
I really appreciate you inviting me on again. You guys run such a fantastic program, and I think everyone's very lucky to be a participant with Constituting America.
Well, thank you. We really enjoyed having you as a guest today. And Jill and Jorn?
Thanks, Cully.
Yeah, thank you for a very involved and informative, keep it very interesting. So
It's always a full contact sport with me, guys.
Well, thank you. Y'all have a great week. Thank you to our audience for being with us, and we will see you next Tuesday at 2 Eastern. Thank you so much.
Thanks.